Good day, my dear audience. Welcome to 2021 World Intellectual Property Forum, the online virtual conference. I'm the moderator, Professor MeiHsin Wang from National University of Science and Technology, Taiwan. I'm the Fellow Royal Society of Chemistry, UK. I'm here for the panel titled Controversy and FRAND for Standard Essential Patent in Court. In this panel, we are very honored to have Sir Christopher Floyd, the former Law Justice Appeal, UK Court Appeal, England Wales, Honorary Professor of Law from University College London, and Professor Rader, the former Chief Judge of United States Court of Appeal for the Federal Circuit and the Rader Group. Professor George Thomas Lloyd, the presiding judge of Germany Federal Patent Court, and Dr. Joseph Kim, the former Chief Presiding Administrative Judge, IPTAP, Korea Intellectual Property Offices, to share their views on the panel titled Controversy and FRAND for Standard Essential Patent in Court. Our first speaker is the former Law Justice of Appeal, UK, England, Wales, the Honorary Professor of Law, Faculty of Law, University College London, Sir Christopher Floyd. Your Honor, highly appreciated for joining this panel. Upon the non-stop improving and emerging technology, standards can be beneficial for everyone because once the standards are chosen, the industry supply chain may enjoy the simplified choice for manufacturing new products and services, while the consumer could also be indulged with the less expensive product and services in a faster manner. However, patent system is meant to promote innovation, while the standard setup could somehow otherwise, if the law and policy are not carefully regulated. There are always controversies upon essential standard patents and its licensing principle, people call FRAND, fair, reasonable, and non-discriminated. There are several controversies. People say standard essential patent will hinder the licensing. People assume the SEP owner will raise the royalty rate to hinder the market competition. Some people argue whether FRAND is really necessary if the total accumulated royalty for a specific technology is always high and standard setting organization may weaken the enforcement of the FRAND. Nevertheless, certain terms of the licensing are required to be disclosed. Therefore, why bother to employ FRAND for SEPs? May Your Honor kindly share your views on above controversies.
Professor, and good day to everybody. I'm very privileged to be here at this important conference. If we can look at my first slide, this is what I'm going to talk about briefly with you this morning. In the courts in England and Wales, we've had a number of quite big cases in which not only have people been seeking to enforce standards essential patents, but they have also been seeking to involve the courts in the settling of the terms on which a FRAND license can be granted. And we've had a big debate about whether that license should just be a national patent or a national patent license or a global patent license. So we have now got a bit of experience under our belts, and I wanted to explain in general the problems which are faced by us, and also suggest an approach as a way forward as to how national courts might avoid competition between themselves and assist industry in settling these disputes, which can otherwise prove very costly and take a long time to resolve. So in this slide, I briefly set out what the problem is. Everybody, I think, agrees that the system under which global standards for telecommunications are are arrived at by international standard settings organization has made really tremendous technical benefits available to the public. So in general, the system, that system is working very well. But intellectual property has proved to be something, as it often is, as of an obstruction because of two things, really. The innovators, the people who make the inventions and propose them to the standards setting organizations, want to get some reward for their contributions. They want to have incentive to come up with good ideas and good technical solutions, and want to be able to charge royalties to implementers. Implementers sometimes are reluctant to pay the sort of royalties which innovators want. And it's generally agreed that innovators should not be able to hold up the adoption of the standard by charging unreasonable royalties for use of their inventions. And on the other side of the equation, implementers ought not to have free access to the market without paying at least something for the use of the invention. So that is the problem which the industry as a whole faced. And it was solved, at least at the outset, and in part, by requiring the innovator to give an undertaking that licenses under any patent which is adopted within the standard as an essential patent, an SEP, should be available on fair, reasonable, and non-discriminatory terms. So that gets over the first part of the problem, that implementers can't be held up, and they may use the inventions which are built into the standard, provided they pay the FRAND royalties. But the one thing that these standard setting organizations neglected to think about when they came up with this solution to the first part of the problem is who decides. Because you would be an optimist, to say the least, if you thought that implementers and innovators were going to agree on the question of what is a fair, reasonable, and non-discriminatory royalty. Now, normally, and I'm sure there are lawyers amongst the audience, normally when somebody drafts an agreement which says something like the parties will agree on reasonable terms, they realize that they're drafting a clause which is somewhat uncertain, unless they include a definition, which none of these agreements do, unless they include a definition of what is meant by reasonable terms, then the clause is desperately uncertain, because it does not provide a means for working out what reasonable terms are in default of agreement. And anyone who's read any number of contracts in the property field, for example, will see that you draft clauses which say a reasonable sum to be settled in the absence of agreement by arbitration or by the president for the time being of the chartered institute of whatever it is the appropriate field to be setting such things. So you have to provide a mechanism, and people who drafted all these FRAND undertakings did half the job by making sure that there was access to the technology, but they didn't do the second half of the job. And they've left it for the industry and the courts and anybody else who gets involved to try and work out a mechanism for deciding what is FRAND. So if we could look at the next slide, please. I've set out there the possible approaches of mechanisms to decide what is FRAND. What the first one is optimistic negotiation, and the parties sometimes do agree, usually after a bit of litigation, what is FRAND, and they settle. In which case, fine, you don't need any external mechanism. But where the parties don't agree, which is probably in the majority of cases, the first possibility is mandatory arbitration. So building into these clauses, not only an obligation to grant licenses, but an obligation on implementers and those who take advantage of the standard to accept a license on FRAND terms to be settled by a particular arbitration panel, which it would have to define. That's quite a good solution if you can make it legally enforceable, and there are various people who have discussed ways in which that might be done. It has its limitations because the has taken the view that any agreement which, as it were, undermines access to the courts under the regulations governing jurisdiction is not enforceable. It's a case called West Tankers, which is a slight. Beyond that, there could be consensual arbitration. The parties could agree on arbitration, but parties that are in opposite interests sometimes can't agree that. And then the only remaining possible, and that's where my experience. Let's look at the next slide. Can we turn the slide over to the next one? Thank you. So when the English courts have been faced with these problems, there's been resistance, it's fair to say, to the national court becoming involved. In favor of the national courts becoming involved, you can say that given that nothing else has worked, the parties haven't negotiated a settlement, there's no mandatory arbitration, they haven't agreed to arbitrate, there's really no choice but to go to the national court. And a second possible criticism that I haven't put down there, but I should mention, is that judges in general, patent judges, are not economists, they're not experts on licensing. They have to be reliant very much on the evidence given by expert economists, licensing experts, and so on. Whereas you could compose an arbitration panel from people who have a real expertise, not just in intellectual property, but in licensing and the economics, and they could see the whole picture themselves. Beyond that, of course, that if the national courts are becoming involved, you get fights between jurisdictions. You get a rush to one jurisdiction because it's perceived to be generous in the royalty rates that it sets, and a rush by implementers to another jurisdiction because it's perceived to set lower royalty rates. And last of all, it may result in a court which has little or no real connection with the licensing operation, being the court which sets the royalty rate. And that is what I've called the problem of forum conveniens, the forum which is not the most convenient forum and not the most appropriate forum ends up setting a royalty which applies in the other jurisdictions where it would be much more appropriate for the courts to become involved. So that last point, I think, is on the next slide. And I've given there a short example We have a company that makes and sells 90% of its phones in country A and markets them throughout the world. Talking about mobile telephones, almost all these cases have been about mobile telephones. And in country B, X sells phones, but only a very small proportion of the market. His total market for phones is represented by country B, 5% or less. But X is infringing in country B, and country B undoubtedly has jurisdiction over an allegation of infringement of patents held by X in country B. And if sued in country B, X will raise what's called a FRAND defense. He'll say, well, even if I infringe, usually he'll say, patent's not valid, I don't infringe. But if it's valid and infringed in the alternative, then I have a defense based on my the FRAND undertaking. I'm entitled to a license, so you can not get an injunction to stop me being on the market in country B. So the court of that country B, says, yes, I've got jurisdiction to try patent infringement and validity, and yes, I have jurisdiction to try your defenses. Indeed, it would be quite unfair to you, Mr. X, for me to try the patent infringement side of it and not allow you to run your FRAND defense. So that's how this country with a small percentage of the total market ends up deciding on what might be a FRAND license and possibly a global FRAND license for the patentee's patents. And that is not satisfactory in a lot of people's view, because the consumers in country A, remember that's where the phones are made and sold, are being requested to, or required to pay royalties set by the courts of country B. And we've seen this in the case of companies like Huawei and ZTE, Chinese manufacturers of mobile phones, not being very happy about the courts in Europe, saying, well, the global rate for this portfolio of patents is so much. So that's the forum conveniens problem, that there's a perfectly good claim to jurisdiction in these remote countries. But the unsatisfactory result is that the defense and the FRAND license are being adjudicated by what to country X are foreign courts. So then turning over to the next slide, please. Just a very brief explanation of how forum conveniens works in a traditional case in the UK. It's recognized that if there is some other available forum which has jurisdiction and which is the appropriate forum for the trial of the action, then the appropriate or natural forum should decide the case. And what's the appropriate or natural forum is the one that has the most real and substantial connection. So that includes convenience, where the witnesses are, where the manufacturer is would be another factor, what the governing law would be, and the places where the parties carry on the majority of their business. Now, the problem with that is the sort of case which I've described, where you have a patent infringement action under defense, is a sort of hybrid case. Half of it is really only triable in the court where the patent is situated, i.e. I've called it country B, which only has 5% of the market, but nevertheless, the courts of country A can't try the issues of validity and infringement because they are generally regarded as the exclusive province of the country where the property is situated. On the other hand, the defense, the FRAND license and setting the terms of the FRAND license, has a different character. And there you would say, well, the most appropriate forum is not the UK. So this is an unusual problem where some issues cry out for being tried in one country and other issues cry out for being tried in another country. So can you turn that to the next slide, please? And that's really what I've set out here. The only viable forum for a patent infringement and validity is the National Court of Country B. But entitlement to a FRAND license may be more appropriately tried in a country where they have a jurisdiction to decide those sorts of cases. Now, the problems being faced by in some of the decided cases so far is that there was a real dispute as to whether the courts of the foreign country would decide on the terms of a FRAND license between the parties. And the law, I think particularly in China, was in a state of development where no one was prepared to say that the Chinese courts would definitely take on the task which the English court had said it was prepared to take on. But I think that will change in the future, and you will have cases where there is a genuine fight as to whether the foreign court is better situated than the more appropriate and natural court to try that FRAND offence. That's why I put in that last bullet point. If B is the appropriate forum for the claim, but A is the appropriate forum for the defence, could the court split the case into two? So turning over then to, I think, the next slide. The possible approach which I suggest, which would meet quite a lot of the criticisms, would be to leave innovators free to bring proceedings of patent infringement up to the point where validity or invalidity and essentiality, non-essentiality and infringement to be decided. But if the implementer is prepared in those circumstances to accept a license, then the trial of that issue should be in the forum conveniens in the country which has the most real or substantial connection with that aspect of the case. Now, we've not yet had a case where that possibility has really arisen, but it seems to me that that at least is a sensible approach which takes account of where things are best tried and decided. And it will remain to be seen whether the courts are able to develop such a flexible approach in the future. But that was what I had to say on that topic. I think there's a final slide in the pack. Thank you very much.
Yeah, thank you for your honor, very kind and comprehensive explanation for the SEP and FRAND with two cases and a possible approach for the remedy. But apart from the SEP and FRAND, as we are aware, after the Brexit, people are wondering what would be the small way to manage an IP, and such as to file new patent or deal with the patent dispute in Europe and UK. May your honor can also enlighten us, because it's a very a privileged opportunity to have you here in this conference, and the audience are from all over the world. They are overwhelming to learn from you. So may you kindly share your view on this after the Brexit?
Well, thank you, Hsin. In this short talk about Brexit, I'd just like to touch on a few things. It's I'm afraid to say, a very big and complicated subject, with all the different IP rights which are having to be modified and changed to take account of the fact that the United Kingdom is no longer a part of the European Union. The topics I'm going to touch on very briefly are the UPC, the Unified Patents Court, and the Unified Patent, the Unitary Patent, I should say. The Court of Justice of the European Union and its intellectual property case law. And thirdly, just touch briefly on trademarks. So the first topic is the Unified Patents Court and the Unitary Patent. So if we could look at the next slide. This isn't really an immediate consequence of the withdrawal agreement, but more or less simultaneously with the withdrawal, the UK announced on the 20th of July 2020 that the UK will no longer be participating in the agreement to create the Unified Patent Court system. And the reason given there, you can see it which is a direct quote from their press release: participating in a court that applies EU law and is bound by the CJEU would be inconsistent with the government's aim of becoming an independent, self-governing nation. So we've known actually all along that one of the Prime Minister Theresa May called it a red line, and it's always been there in the background, that the one of the objects of Brexit was to cut the UK off from the influence of the case law of the Court of Justice of the European Union. So it looks, at least on the face of this press release, that the benefits to industry of being able to enforce a patent for the whole of Europe in one single action, and of having a unitary patent which covers the whole of one of the largest markets in the world, were as nothing compared to what one might describe as a doctrinal allergy to the influence of the Court of Justice. In fact, the Court of Justice was to have an extremely limited role in the functioning of the UPC. The UPC first instance court was to have its own court of appeal, and it was only in the application of EU law where the possibility of a reference to the Court of Justice might come in. And of course, the majority of substantive patent law is not EU law. It's not part of the acquis communautaire, but is the law of the European Patent Convention, which is not an EU treaty. So anyway, that's what's happened. And the first consequence, therefore, of Brexit is that the Unitary Patents Court will not have the participation of the UK, and if it goes ahead, which it seems likely to, our industry will not have the benefit of being able to use its facilities so far as the UK market is concerned. Of course, British companies could bring an action in the UPC, but that's a different matter. So that's the UPC, and as you've already seen, what's behind the government's decision is the Court of Justice of the European Union. And I thought it might be worth just spending a moment or two on understanding what happens to the jurisprudence that we have has been built up over the years by the Court of Justice in intellectual property, now that we're no longer part of the European Union. This has been a subject of much debate in government. At one stage, the proposal was that decisions of the Court of Justice would have the status of decisions of the Supreme Court, so that although we were no longer bound by the CJEU, they would be deemed to be Supreme Court decisions and binding in the UK, and therefore could only be departed from if the Supreme Court decided to depart from them, and so inferior courts would continue to be bound. That's no longer, as I shall explain in a moment, that's no longer the way in which it's to be treated. But whatever precise regime falls to be adopted, our law will therefore be able to diverge from EU law in trademarks and in those areas of copyright law which have been harmonized. They may start to diverge as well. Those parts of patent law which were governed by EU law will again be able to diverge, but whether they will, we can only wait and see. So just thinking a bit more about the CJEU on the next slide, if I could. As I've said, the original legislation contemplated was that only the Supreme Court could diverge from CJEU decisions. But the legislation now provides that appellate courts, so that includes the Court of Appeal of England and Wales, the Court of Appeal of Northern Ireland, and what is the Court of Appeal in Scotland, but it's called the Court of Session in Scotland. All those courts, in addition to the Supreme Court, will be able to depart from CJEU case law. But this freedom doesn't sort of, as it were, continue indefinitely. Once a particular court has considered and decided whether to depart or not to depart from a CJEU case, then that decision becomes binding, and they don't have the same freedom all over again next time they come to consider it. So you can't get an iterative, repetitive process of departing from CJEU case law. So then going over to the next case, other rights, trademarks and other non-patent rights. The EU trademark will not cover the UK, and so this has necessitated the creation of a brand new UK right called a comparable trademark. So if you had on Brexit Day, if you had an EU trademark which extended to the UK is excised from that trademark, but in return you're granted a comparable mark, which is supposed to be in all respects identical to the mark which you had before Brexit. And it's going to be called a corresponding EU trademark. So that's what you have. And in all the other fields, the UK has enacted a really enormous number of pieces of legislation designed to ensure continuity of protection of all IP rights, notwithstanding Brexit. It's been a very complex operation, and no doubt there will be quite a bit of litigation about what the transitional provisions mean. But the legislators have attempted to deal with the problem. Of course, one particular concern, which could be the subject of an entire discussion, is the question of exhaustion of rights and which particular road one goes down when deciding whether a right has been exhausted by putting the product on the market. But I'm not going to attempt that in our short discussion today. So then just turn over to the next slide. I hope that's been given a flavour of what Brexit means for IP rights. I think the overall message is that the legislators have striven for continuity. The big disappointment, at least as far as I'm concerned, is that the UK will not be part of the Unified Patents Court, which we worked so hard to create.
Yes. Yeah, thank you very much for your honor. Kindly enlighten us how to manage IP in the new era after the Brexit. And thank you again for bringing us very meaningful and comprehensive explanation about the SEP and FRAND, how we should learn and how we should deal with that. It's getting more and more intriguing, and let us continue to follow development on SEP and FRAND and the situation after Brexit, and hope we will soon have the coming opportunity to learn from your honor again. Thank you very much. Thank you, sir.
Thank you for inviting me.
Thank you, sir. Is there any additional point or comments you would like to address? Anything apart from what you have been sharing to us? Additional point?
I don't think so.
Okay.
No, I hope it came across all right.
Thank you very much. So I hope after the pandemic ended, we can invite you to Asia and see you face in face and to meet all the friends here. Thank you very much. Thank you. Our next speaker is the former Chief Judge from United States Court of Appeal for the Federal Circuit, Professor Rader. Professor Rader, would you mind kindly share the current controversy on SEP and FRAND in United States?
Thank you very much, Professor. This is indeed a very fascinating time in our international intellectual property system. And it is important to recognize as my first theme that the intellectual property system is indeed international. You cannot adequately protect your intellectual property by remaining just within your own national borders. Technology knows no borders, and thus protection of that technology must extend far beyond your own borders. That leads to an interesting paradox, because enforcement systems are all national. They are limited to the extent of one nation's borders. And yet, as I expressed, the technology is not limited by those borders, and the protection must go beyond those borders as well. And that creates a very difficult and challenging problem of enforcement beyond your own national borders. That is even more difficult in the area of standard essential patents, where, of course, the standard as well as the technology extends beyond borders, and therefore enforcement of those standard essential patents must be of an international character, yet pursued often in a national forum. We're all aware that in the Unwired Planet case, one nation, the United Kingdom, said, we will be happy to accept these standard essential patent cases and give as a remedy an injunctive relief that will only be withdrawn if there is an international license. Well, this poses some difficulties because the international license, even if it can be enforced with an injunction within one nation's borders, even if that is possible, and I have some qualms about that, the international license would have to be different in different marketplaces. A technology does not cost the same in China as it does in India, as it does in Brazil, as it does in other markets and nations. And so each market really needs its own separate determination. That leads to, of course, the problem of national enforcement to achieve those proper market compensations in different locations, but without impacting other markets. All of this theoretical conversation really gets us to the point of anti-suit injunctions. If you sue in your own home country to set a license rate for the standard essential technology in that location, the automatic result is that the other party will file in their home country or in a different location at least, and in a different market, seeking a different rate. And as those two national courts confront each other, often the result has been an effort to enjoin that competitive rate setting institution. To use the most recent example, you had, well, let's use a hypothetical example. You could have a Chinese company who may wish to sue in Shenzhen or Wuhan or Beijing to set the rate for the use of the standard essential technology. They may be suing an American company, and the American company may say, we would prefer to set the rate here in the Eastern District of Texas or the Northern District of California, U.S. courts. And in several instances, we've had the Chinese court, Wuhan or Shenzhen, enjoining the activities of the parties to enforce their judgment in another locality, in California or Texas. We've had the same result in California and Texas, where the courts there have enjoined any enforcement activity on the same technology and the same patents in China or other locales. I think this is leading to a conflict between these courts as one court tries to rush to be the first. Timing becomes important sometimes. Which court first had the case, which court first filed the injunction. And so there's a race to be the first court to be handling it. All of this sacrifices the doctrine of comity. Comity is a doctrine which suggests that courts should respect each other's jurisdiction and, if possible, defer and let another court handle their national cases while you are handling your national cases. Of course, the problem here is it's the same case with the same patent and the same technology. We, of course, have the problem that if the Texas court, for instance, does not stop an enforcement action in China or Japan, then the case in Texas may be prejudiced because the parties will be forced to settle before the case can be fully heard, forced by the prospect of a punitive injunction in their in the other forum, the Chinese or the Japanese forum. Well, there are some potential solutions. I tend to think the best solution is a arbitration proceeding where the parties consent to select their own judges. By the way, I have done several of these arbitrations in the standard essential patent area, where the parties can select their own panel of judges and submit the entire international dispute to one forum and one resolution. That's very convenient. Now, it's criticized sometimes because the arbitration tribunal, of course, does not have the power to invalidate a patent. They can, of course, weigh the principles of validity and refuse to grant any weight to patents that they perceive are likely to be invalid. So validity plays a very important role in an arbitration proceeding. But the party who is implementing the technology loses the threat that we will invalidate your patent if you go forward with too high a royalty rate for use of the technology. I have found, by the way, that the tribunal, the arbitration tribunal, can, by taking into consideration validity, negate the problems of that I'm suggesting. But it's nonetheless a factor which weighs into this consideration. An alternative outside of the parties agreeing to arbitration may be some effort to recognize that each jurisdiction has its own authority to resolve disputes for their own marketplace. And so if there is some way that the courts can acknowledge an expanded comity doctrine that will not compromise another court's ability to resolve its dispute in its market while achieving a result within their market. In other words, the Chinese or Japanese court could resolve the issue expressly stating that they are doing it just for the market within their control. And the Texas and California courts could do the same. Now, this has the same problem, however, as the validity concerns in the arbitration situation, meaning that the patent owner is losing leverage to impose its royalty worldwide and thus obtain a settlement on a better basis. And so it shifts the difficulties of it compromises the leverage which a party would otherwise have if their local proceeding could have an international impact. Well, this is a subject we could discuss, Professor, for many months, and we could discuss the various cases that have implemented these procedures and the conflicts between Chinese and American courts, and the allegations that one court system is better or worse, or more available or less available, or the first or the second place of filing. In sum, none of these arguments are really the key. The key is going to be some kind of agreement amongst the users of this system, the large international companies, that they are going to submit their disputes either to a single forum where all international issues will be resolved at one time, or that they will accept an adjudication of their international dispute in different places, in different markets, and under the rules of different national systems. I find that quite inefficient and expensive, but there are at least some of the issues, Professor, that need to be dealt with in the area of international enforcement of standard essential patents.
Thank you, sir, for sharing your view on FRAND and SEP in United States. And you also kindly offer an alternative for arbitration to deal with the patent dispute. May you kindly give us more specific about the process, how the mediation arbitration will be taken place?
Professor, you asked me to discuss how a mediation might go forward in the standard essential patent area. Mediation, of course, is a procedure which brings the parties together in an effort to settle the case without full litigation. I have done several mediations. They begin with each party submitting a statement of 20 or 30 pages to the mediator, and I acquaint myself with the facts of the case. Then we schedule a meeting. We are all together on Zoom, usually, this kind of a medium. I give a speech, which I won't repeat here at the beginning. In the basic points of the speech are that they need to genuinely seek to understand the other party's interests and their genuine needs. I then break them into two separate rooms, and I go to each party in succession. I discuss the strengths and weaknesses of their case. I discuss the great costs of proceeding with litigation, particularly if that litigation is going to be in 4 or 5 or 6 different nations. And I acquaint them with how they will have to send their corporate executives from one court to another, and how that disrupts their business. And then I try to encourage them to see a path towards a settlement. Now, the key often comes when we start putting numbers on the whole process. And the numbers can start with the mediator. The mediator often will give his assessment. I would give my assessment of what I think the value of the case is to each party, or I encourage them to do that. And then I take that starting point, and of course one party will say it's much too low and the other party will say it's much too high. I will point out that well, they have to take this into consideration, and when they do, that number will come down or go up. And over a period of many hours, usually, I have done a mediation that went for 30 hours, continuously, no sleep. But we achieved our result, and the parties settled the case. And they came to a royalty payment in terms of a percentage of the revenue generated by the patented product. And both parties were happy with that. And we reached the result around the 22nd or 23rd hour, but it took many more hours to reduce that to legal language. One party would propose a paragraph, and the other party would amend it, and we'd go back and forth for many hours. But that achieved its result. And in 2 days, or a day and a half, we had a resolution that, if the parties had litigated, would have taken them months and years and perhaps millions of dollars in expenses. Does that help, Professor?
Oh, yes, very much. And I think they help industry to understand how the mediation will go and the process and the preparation and the benefits they can receive. So I think this is a very good experience sharing. Thank you very much, Your Honor. We hope we will have another opportunity to invite you to share more insight experiences. Thank you for helping the industry for your whole life. You have been teaching internationally for student industry and guiding many countries for their policies. You are a genius. You are a legend. Thank you very much again. Thank you for sharing. Our next speaker is Professor Thomas Vogt from Germany Federal Patent Court. Your Honor, would you mind kindly share your view on SEP and FRAND in Germany?
Thank you, Professor Wang. And a good day for you, ladies and gentlemen. And I'm very honored to speak to you. As I suppose you all know about the SEP problem, or what a SEP is, I will jump pretty direct into the medias in res in Latin. So in the middle of the problem, on the one hand, we have an increasing number of standards nowadays, for example, in the automobile industry, or in the telecommunication industry, or in the IT industry, because there are global markets, and you have to comply with standards wherever you are. On the other hand, there is an increasing number of patent granting. So, for example, we had an increase of 7% from 2018 to 2019. If you look at the WIPO statistics. So, the next slide, please. And if you look at the SEPs on first sight, SEPs are a good investment for the owner of the SEP because everyone has to comply, and therefore everyone needs a license for your patent. There were less problems as long manufacturing companies owned the SEPs, because this was some kind of a closed shop, which means if one company had an SEP, the other company who wanted a license, then they made an agreement like a cross-licensing or anything else, and therefore there weren't many problems. But about 10 years or a little more, 15 years ago or so, most companies sold parts of their company, and it was called concentration on core competences, and therefore a lot of SEPs appeared on the market, and a lot of companies bought the SEPs and are now on the way to make money with the SEPs. Please, the next slide. And if you look at the antitrust law, SEPs are always a problem because you have some sort of monopoly on the one hand, and on the other hand, with the standard, you can impede the technical progress, also the fair competition. Therefore, some organizations like the ETSI in Europe or the ITU made agreements like FRAND, which means fair, reasonable, and non-discriminatory. And therefore, they had developed some agreement positions. Next slide, please. And I want to give you some examples because from the beginning the jurisdiction tried to apply the FRAND regulations, and we had our first decision in Germany was the Orange Book standard, which means some standards handling with CDs, compact discs or DVDs. And therefore our Federal Court of Justice made some points or stressed out some points. And the second important decision in Europe was the decision of the Court of Justice of the European Union. It's called the Huawei versus ZTE case, which took place on July 16, 2015. Next slide, please. And both the Federal Court of Justice in Germany as well as the Court of Justice in the European Union that there could be an abuse of a dominant position if the patentee prevents others from access to the market, at least if the patentee has agreed before in the FRAND regulations. And so the Court of Justice of the European Union stated you have to get a license if you make an offer to the patentee. But the Court of Justice of the European Union also said you have to make an offer to the normal condition, which is usual to get a license. So this always had been a problem because nobody knows the normal standard for a license. Nobody knows how much percent of the price you have to offer. And so a lot of courts said we can't work with this things made by the Court of Justice of the European Union. And therefore, there was a new decision last year. Our Federal Court of Justice made a decision. And here it said that a dominant patentee could apply for an injunctive relief, also for destruction claims or recall, if the competitor don't make any efforts for gaining a license. This case was called Ziswell versus Hire. And in the same decision, the Federal Court of Justice went back to regulation in the German law, which is called, or which is Article 315 of our Civil Code, wherein is stated that you only need to make an offer without any need for telling an amount of the license fee. You only have to offer, I want to get a license, and then the court can decide about the license fee. So that's a little bit new because you don't need to make a real or offer a real number for the royalty. You only need to offer, I want to get a license and I agree with a license fee for that, but the height of the license fee will be decided by the court, and the court has to decide with seeing all circumstances, and so you can be pretty sure not to get a too high license fee, but also not too low a license fee. But another point of view in the decision Ziswell versus Hire is that the Federal Court of Justice also said even if a patentee is a dominant patentee, it can also use all enforcement for its patent, and also can bring the license seeking a company out of the market. So it's on the one hand an enforcement of the position of the patentee, and on the other hand little relevation for the license seeking company. So it's a pretty Solomonic decision in my point of view. But some people say there is an over-enforcement of the patent, but I don't think so at the moment, to be honest. Please, the next slide. Yeah. The case dealt with a part of the GRPS standard, also, but it's a part of the mobile communication standards. You may know it's a general radio packet standard, and therefore, if you're dealing with mobile communication, you know there are a lot of standards on the market or in the wild, I would say. And there is always the problem to deal with the abuse of the dominant position on the one hand, protection of the market, of the free market on the other hand, and therefore the Federal Court of Justice wrote a long decision, about 30 pages, I think, and the only preposition was in this case that the license-seeking company was not willing a license because first it did not answer within a period of more than a year upon the patentee's request to get a license. And in addition to that, the court did not see a serious license offer by the potential licensee. And therefore, the Federal Court of Justice stated higher demands than the Court of Justice of the European Union, but that's only for this case, in my point of view. And on the other hand, you have to respect the Article 315 procedure, which means that you have only to offer, I want to get a license, but the royalty should be decided by the court. And some people in the literature said, oh, the Federal Court of Justice had here a patent over enforcement, but I don't think so. I think it's a quite wise decision by the Federal Court. Please, the next slide. Naturally, there is a difference between FRAND cases and nullity cases concerning SEP. because FRAND is part of antitrust law, and in annullity cases, there only the validity of the patent is the base of the decision, no matter if it's a SAP or not. If you're dealing with FRAND agreements, I think also the FRAND agreement is a quite wise decision, because it's the only way to comply with antitrust legislation, because you need something to hold the market free from a monopoly, which is a pretty important thing. Another problem with the SEPs nowadays, as I mentioned before, is because there are a lot of NPEs now on the market, and NPEs normally are not very interested very much in a settlement, and therefore you have to go along always with a dispute, or a real dispute, because the NPEs only want to get commercial exploitation of the patent, and not like it was before, only to go along with your competitor and get some other advantages from your SEP, for example, a license for another procedure or another thing, like it was before, as long as it was a closed shop between the companies on the market. So I think the problem is more that a lot of SEPs are used to gain money only, and not to solve the problem with economic consciousness, I would say. Yeah, and that's unfortunately a thing which came from the big companies mostly, because they sold a lot of SEPs also to get money from the market. Yeah, that was my presentation, and I thank you for your attention very much. And we can start the discussion or the interview if you want, MeiHsin.
Thank you very much for your honor. Give us very comprehensive true case and issues, how to deal with the royalties and validities as well. Because in the business world, price to reflect with the quantity sometimes is reasonable, but the licensor always insists they comply with FRAND, but however, there are lack of information equivalence. So the licensee feel otherwise. Therefore, everybody rush into the court to seek for the justice and to make the judge very busy and have to consider all the statistics, all circumstances to decide what would be the reasonable royalties. Currently, regarding the validity, we are aware your court are very specialized in the validity issues. We were just wondering because nowadays people they tend to use AI to help to identify whether the patent is valid or whether the patent are the true essential standard patents. For example, in the United States, they have the TCL case and Hsin case. They use a software they involve to analyze the patent. So I wonder, is there any fashion in Europe how you could identify the true validity of essential standard patents? Because in old days, they always have independent experts. So what would be the trendy fashion so far in Europe?
I think the simplest way would be if you look at the real standard, and if the patent itself covers a part of a standard, then you can assume that you have a SEP. And mostly the patentees will make the standard as a part of the suing, because they say that's a standard which is from the meeting so and so, and mostly you have the protocol of the meetings where you can see okay, there was the beginning, then the company A brought in this argument, and the company B came with this argument, and then mostly 6 months or later, the standard was fixed, and then you can see, okay, I know that's an SEP. So that's the most usual way. Sometimes you can't see really a standard essential patent because the parties don't say that's a standard essential patent. Because if you come with a standard essential patent to the court, the court's fee will be higher than it's a normal patent without the character of an SEP. But mostly one of the parties say, okay, that's part of the standard. And I never experienced a case where not one of the parties wrote in the protocols of the meeting. So mostly, you know, that's a part of the standard.
Thank you very much. Thank you. Thank you very much.
Question? Yeah.
Yes,
okay.
yes. It's very very meaningful for people how to learn whether they should disclose their patents essential standard patent, because the fee will be different, and how we can refer all the protocols from the IEEE or SSOs to learn to identify whether the patent is indeed a SEP. So thank you very much for your very comprehensive explanation and sharing all the cases and the rule, principle, protocols in Europe. Sometimes AI may take part to join the independent analysis, such as the software OPEL, which represent objective pattern landscaping to conduct machine learning. But should we trust human expert or machine learning, or human and machine cooperating together? But to what extent? Our next speaker is Dr. Joseph Kim, the former Chief Presiding Administrative Judge, IPTAP, Korean Intellectual Property Office. Dr. Kim, may you kindly enlighten us the SEP and FRAND issues in Korea?
Well, first of all, thank you for your introduction, Professor MeiHsin Wang. Good afternoon, ladies and gentlemen. It's my pleasure joining here on the topic of controversy and FRAND on SEP IP code. Usually, I do share my view on this from my industry experience. Well, under the COVID-19 pandemic, every audience and attendees in this panel discussion, be strong and stay healthy anyway. All right. So first of all, to your questions, whether FRAND licensing is hinder the licensing or not. Well, FRAND license itself-wise, it does require to have a FRAND terms in the license agreement between SEP holders and potential licensees. Well, in short, I believe this is very useful for innovating and promoting the technology, especially defined as standard technology in the telecommunication area. So it would be very useful in that regard if we overcome some controversies that we are talking today. So under the current situation, this is more crucial than ever, considering the expanding business in the coming, fourth industrial revolution. Well, such, technology, AI, IoT, and perhaps AR and so on, those are important things. So to establish a FRAND license, it's necessary to analyze the licensing agreement, whether SEP owner has agreed with FRAND terms with other licensees. So in view of FRAND, licensing terms must be a kind of FRAND terms and be transparent in view of FRAND licensing. So in that regard, FRAND terms is the most important part. What is FRAND terms? That's important key issues. Let's say most likely FRAND terms is very thorny issues because it will become a different animal in view of licensor and licensee side. Of course, there are several other factors to be considered when we define FRAND licensing, such as negotiation in good faith, whether there were any FRAND offer and timely FRAND counter offer, and how about acceptance? That's whether that's based licensing guidelines anyway. So to see what's the FRAND rate is the key issues in judging the FRAND terms. To judge the FRAND terms, what would be the reasonable or the fair FRAND rate as one of key issues. In most recent cases from the court, judges really handles the definition of FRAND rate. And they approach it in several ways, such as top-down calculation and bottom-up approach, or establish comparable license. That is, most important part. So, how we can maintain FRAND rate in FRAND licensing? That's key issues. But in my experience, the standard friend rate must be provided by potential licensors anyway. Especially, there are two types. If it goes to SP holding company, such as manufacturing company, so manufacturing company versus manufacturing company, it would be very reasonable because both company knows what's the definition of friend rate and the secret of standard of essential definition, patents, and also other things too, business environment, very similar. So they can balance either party's patent portfolio, and normally they take into cross-license agreement. I don't think it's not, so unfair in view of, SEP manufacturing company-wise. But when it goes to SEP holders, such as NPE versus manufacturing company, that is much more problematic. Why? Because NPE does not have any backfire at all when they come to manufacturing companies. So in that regard, what would be a really reasonable and fair friend rate? Which means that friend rate wise, always it must be provided by the licensor anyway. So if there is a friend license of a friend rate, I think to a certain degree, MP must declare what is the friend rate. Why? Because they have no backfire at all. And also be fair to all potential licensees in the industry. So they set up a standard friend rate, then it must go lower, considering all other factors. That is most important things. Of course, there's no way the licensee keep a one license agreement that applicable to all licensees having the same royalty rate. It's not possible. It must be varied a little bit. That is the current situation. That's why people are complaining a lot. But in short, I believe in the case of MPE, they must declare their friend rate to a certain degree to the relevant industry. That's important things. That's my understanding. And it goes on the further about world global license. In several courts, they granted global world license. Well, that's much more severe to a certain company, such as small and medium companies, national, country-wise, which means that the company is not enough to cover the whole world. Why they have to take a worldwide global license? How come they have a single country basis license instead of world global license? I think that must be considered very serious. Why? Because friend dispute wise, this issue is independently separate jurisdiction from country versus country. That's why, in that sense, I strongly, suggest that kind of licensing type must be acceptable as well. And other things is, SSPPU, the smallest sellable patent protecting unit. That is critical issue to calculate the damage issues. Well, this concept has become very popular since it was born and introduced, one of my good friends, Judge Rader, in Cornell versus Hewlett-Packard cases. And it's been said that this issue has been determined by judges, not by damage expert, even if, damage expert may say different way. But as you know, SEP has patent which claim covers an aspect of technical background, whether it's Apple, whether it's computers, mobile, the party implement the standard into commercial product. When court judges decide of infringement of the product, there must be either reviewed and identified by a product basis. But what is the product basis? That is important too. Well, the product means that the product must be covered by the scope of claims in the patent. It doesn't go beyond the product, what the reach of its asserted claims. That's too broad. Well, of course that, the patent holder can say that, well, it said that make, use, or sell, which means that if, one small component that included whole part of invention, still that component can be integrated into our end product, set product. In that case, they say that, well, the set product as a whole is the royalty-based product. But in return, if it goes beyond that, the whole world become their royalty-based product. Absolutely, that's not true. So that what I'm saying is SSPPU is very important concept. It's not only limited to such as component. It is whole spirit of infringing theory in the court, which means that that is the royalty-based product and it must be decided by the judge. Of course, sometimes jurors in the United States may decide different way, but still, it must be corrected. It happens in the jurors' verdict by the judges. Judge must decide the infringing product. And then that infringing product is the base of royalty rate base. I think that's important, whether regardless of EMBR, what people say that entire market value versus SSPPU, in my view, that's not parallel sizing concept. It's one concept, but when damage expert interpret the damage amount, they approach in a slightly different way. But in my sense, in my view, it must be decided, court judges, it's well defined by the law already, so that, in the future, regardless of SSPPU and EMVR whatsoever, doesn't matter. What is the infringement decision and what is the accountable, corresponding product, infringed product? That is all in my view.
Thank you very much. Yeah.
Go ahead. That's first question. Anyway.
Yes, first question. Okay. So thank you very much for your very detailed and comprehensive experience sharing based on your work experience in the court and also in the industry. But there's another controversy about the information. The SEP owners, they claim their compliance with the FRAND guideline. They always say so, but it would be a true novelty if they sincerely disclose every piece of necessary information to all the clients, as we can review the cases such as TCO or versus Ericsson's. There are always arguments. But however, as you mentioned, in the business world, the price should be reflect to the quantity. That's reasonable. Nevertheless, there are more factors, skills to influence the price, such as the negotiation skill, market power, policy, connection between companies as well. So the licensor always insists they already comply with the FRAND, but however, the lack of information equivalency, the licensee always feel otherwise, and they have to see the justice or remedies from the court for the training faction, and the court have been due due diligence to calculate all the royalty rate based on all the statistic data, or even depend on AI to identify what is the SEP, what is not SEP. But may Your Honor kind of share the view, because currently how to confirm the SEP pattern is still kind of issue, though there are a lot of independent expert, co-expert, standard organization, etc. But based on your opinions, how can we accurately confirm the SEP? And then if it's only when we can accurately confirm the SEP distribution, then we can accurately calculate the royalty rate. So we really depends on your experience sharing for the current controversies.
Okay, well, regarding information disclosure about FRAND rates, well, that is one of the key issues in the, intellectual property licensing matters, which means that parties do agree to enter an NDA agreement when they are involved in licensing negotiation. Well, that is important thing, that confidentiality agreement, what's being called otherwise. But this is a common business practice used to protect commercial interest of a licensor or a licensee, because they have to keep a certain degree of confidentiality when they are involved in licensing negotiation. Well, that's very common. But if that happens, then the licensee cannot disclose their licensing, terms, especially FRAND terms, to others. And also, they don't have the opportunity to get some other existing licensees' FRAND terms at all, which means that they don't know whether they have a FRAND terms or a FRAND rate at all. No way that they can find it unless they will compare their FRAND terms with the other licensee terms. That's pretty unfair. I do agree with that. But in that sense, I normally request for the potential licensors saying that, well, for the confidentiality, absolutely keep in secret. But the most important part is that the other licensees' FRAND terms must be disclosed so that we can choose which term is relevant to us and appropriate to us. Other than FRAND rate, rate itself is very important things. And also, I believe that's very fair request to the potential licensors. I cannot disclose whether I received all that information already in my previous licensing negotiation or not, but to a certain degree, I did have enough information anyway. So that in that regard, my point is that if there is a potential licensor and potential licensees, considering the licensing negotiation, the potential licensee must have enough information about their choices in getting the fair and proper FRAND rate. That is most important part anyway. Even if, they don't disclose it, once two parties go into the court, well, indirectly, that kind of information must be disclosed anyway. So to, show FRAND terms must be disclosed to imminent potential licensee during the negotiation if they signed NDA. That's important thing. I think that's fair request, and it must be accepted by the potential licensors as well.
Thank you.
I don't know whether that's enough to your questions or not.
Yes.
But
We will further would like to incur your expertise because you have decades working with LG before you join IPTAP, Korean Intellectual Property. And actually, you are the legend in this work. So in IP world, so would you mind just give us, enlighten us how you confirm when the subholders, they come to you and they claim their conditions, their royalty rates, their profile, how can you confirm the sub patents? Because a lot of time they're bluffing a lot. There's always more than they claim. So how you deal with these negotiations?
Well, that's very good questions. Well, many licensees may have a question whether they are paying the royalties under qualified standard essential patent or not, which means that they are paying a lot on false standard essential patent, or
Yes.
perhaps invalid standard essential patent. That is, if that happens, it's crazy. You know, they are paying a lot more than any other body.
Yes.
And, you know, usually the standard setting bodies such as ETSI, ARIB, and CCSA, they are not liable about verifying standard essential patent at all. But here's one big issue: is the headache is that over declaration
Yes.
as a standard patent before standard setting bodies, because they are not, you know, verifying at all. They just receive it once the formality is met. So that if this problem will go to the practical area, such as SEP holding company versus SEP holding company, well, I don't think that's so problematic at all. But still, if it goes to MPE, SP holding MPE versus SCP company is headache, because SCP holding MPE do not have, you know, defenses at all. They just hold the papers and asking for money. That is problematic. But most case-wise, SCP holding company, you know, does have some internal resources to verify standards essential patent. But if it goes to small and medium companies, they don't have enough resources to verify standard essential patent internally. So if it goes to, you know, big company wise, I think they will resolve through technology meeting between two normally. But if it goes to MP versus manufacturing company, that's problematic. In that case, well, normally in a pool licensing wise, what's been, you know, suggested were that pool licensing entity designate several, you know, neutral qualified companies and law firms, and they can review it and report it to the, you know, pool licensing entity, whether those are verified standard essential patent or not. That's a normal way our pool licensing entity is you know, accommodating. So that's one way. The other way is that, well, even if that's not suggested, if potential licensor and potential licensee, if they agree, they do need to have a you know, third-party report saying that this is, you know, standard essential patent or not. Simply, potential licensees cannot rely on potential licensees' argument. These are, you know, standard essential patent, because these are declared standard essential pattern before the standard, setting bodies. Actually, that's not enough. So that I think we does need to have a neutral, qualified party, such as law firms or, such firms. We do need third-party report between two. I think that's a fair request as well. And then, the potential licensee can review the report and may argue further and decide later. I hope, nowadays is AI era, so that I hope AI system may help this problem soon anyway. That's my personal hope, but if not, is third parties report is the most important part, and that's one solution for that.
Thank you very much for your honest, in-depth, and comprehensive explanation. It helped us clarify a lot of controversies on SEP and FRAND. Thank you, Dr. Kim, for your very kind sharing. Before we close in the panel, we're wondering, is there any comments you would like to suggest or address to further teaching us a little bit? Yes.
Things in addition to the previous comments, to resolve all of these headaches, we need to have certain tools and vehicles. What is that? As people say, and also, courts say slightly different interpretation of FRAND terms and FRAND licensing. And that is very, natural. Considering that, I strongly suggest that each country must have a standard licensing guideline for SEP based on country basis. So at the minimum, a standard licensing guideline must be announced so that everybody understands what's the licensing environment in a certain country. I think that's important things. Thank you.
Thank you, sir, for your very kind suggestions. Before we close the panel, on behalf of the conference organizer and the audience, we would like to address our sincere appreciation for your honest, very kind sharing and very meaningful, very knowledgeable teaching. We hope in the near future, we will have the opportunity to invite you back again for a more enjoyable panel discussion. Thank you all.